and I'd like to introduce Ellen Efros, who is the facilitator of this course, and she will give us an introduction. Thank you.
Good afternoon, everyone. Please let me know if you cannot hear me because my voice is very scratchy. Yesterday, I sort of got a little bit of laryngitis. We gave our first course on imminent or important Supreme Court decisions last fall, and it was so popular. We had a good group for each of the 7 sessions, and I was asked by many members of ILR, and I don't want to just say OCAMICers, but members at large of ILR, please do it again. So I went to my presenters and who all participated last year, and they were all willing to jump right in. So I really appreciate their support in doing this program. Our presenter today is John Mills. He's the Emeritus of the Levin College of Law. And he's also the co-director of the Center for Government Responsibility. And I think you can see that on the screen that he's sharing with us. John and I talked about 2 major factors in his presentation today. One was on the abortion issue. That was even before the Texas decision, which now has proved to be a real challenge, both for the current administration, and it will be a challenge going forward. And I would expect, and John may disagree with me, but I would expect this to continue to be a very hot button issue next year at SCOTUS. The other thing we talked about briefly was John's perception of where this court may be going, and whether or not there's going to be an attempt to do court packing, or what one of the judges will retire so that Biden can appoint someone who's a little younger and will be around a little longer. So with that presentation or that introduction, I want to turn this over to John and let him do the talking. At the end, we will take Q&A, and you all know how to do that. Either, raise your hand, wave at us, or use the raise hand on your Zoom list. So hold your questions till the end, but we will be sure we will get to them. Thank you.
Well, thank you, Ellen. And it's always a special pleasure to talk with the folks at OCAMIC. I've always told my students that this is probably one of the roughest audiences on the planet, because we have all these retired smart people who have good questions. But I welcome the opportunity to be here. My mother was a resident of OCAMIC and one of the early ones, and she loved being there. There are a couple other things about me that are not on my general resume that I was going to mention that give me a background and have changed my view on some things. I'm a 2-time cancer survivor. I've had a driver's license for tanks and airplanes, which you can interpret various ways. I was a national co-chairman of an unsuccessful presidential campaign. Someone will guess who that might be. It won't be easy. And I've been married for 31 years and I have 2 daughters. And I have a special interest in the rights of women, and so do they. So the issue that we'll talk about today is the evolution of abortion law in the United States. The Constitution of the United States has come to recognize a number of issues as fundamental, and that is they are individual rights which the government has to provide deference for. Those include family decisions, procreation, reproduction, intimate personal relationships. And in beginning with Roe versus Wade, identified the individual right to an abortion as a fundamental right. There are a series of cases. I'm going to run through these cases and talk a little bit about the Texas case and the Dobbs case, which is pending in the United States Supreme Court, set for oral argument December 1st. Roe versus Wade recognized abortion as a fundamental right and a privacy interest. There have been other privacy interests that were recognized, including contraception. So there is, once an interest is recognized as a fundamental right, the state must show a compelling interest to intervene in that right. And the Roe versus Wade decision established the trimester framework to balance state interest, and that in the first trimester there would be no regulation. And this is Roe versus Wade is establishing a constitutional right, and therefore state laws cannot override that constitutional right as defined by the courts. The 1992 case of Planned Parenthood versus Casey, this again confirms that the 14th Amendment supports the right to terminate a pregnancy, but then began redefinition. That means, in this case, prior to viability, the state cannot prohibit abortions, but after viability, they could. And then Casey is also the case which introduced the standard of undue burden. And if you view this in constitutional context, undue burden is a little different than establishing something as a fundamental privacy right. In fact, some of the rights that have been interpreted lately in post Roe are cases that recognize these interests as liberty interests. And liberty is a word that is in the Constitution, privacy is not. So the state can regulate as long as it doesn't place an undue burden on the access to abortion. And this line has not been terribly specific. And so you can see these are examples that were not undue burdens. Waiting periods, licensed physicians, partial birth abortions, and that the state is not obliged to subsidize or provide facilities for abortion. The state is not. In whole women's health, which is much more recent, this is the 2016, and this is a Texas law as well, interestingly, that a physician having, any physician would be required to have admitting of privileges at a hospital within 30 miles of where the abortion would be performed, and all clinics would have to comply with standards for ambulatory surgical centers. Well, the court here considered the cumulative burden of these various regulations and said that the cumulative effect was that there was an undue burden. And also in dealing with this as a balancing issue, what is the state's interest and what are the interests advanced by the state? And they did not, in this case, show that the state's interest in protecting women's health was substantial enough, while at the same time there was a substantial burden on the rights of individuals and an undue burden. So again, Hellerstedt continues the line of cases upholding abortion rights, but continuing to define them somewhat more narrowly. in 2020, June Medical Services versus Russo, this is the most recent case, and it is interesting for several reasons. It's a Louisiana case, and fundamentally, it's not all that different from the Texas case. So the district court found that these privileges result in a drastic number of geographic distribution of abortion suppliers, and 4 members of the court clearly upheld this under whole women's health. But the interesting decision is Chief Justice Roberts. Chief Justice Roberts, who probably would not have voted for this had there not been precedent, but upheld this case based on the precedent of whole women's health and the concept of stare decisis, that this was a quite recent case and the facts were virtually identical. And therefore, because there was a decision that upheld this decision would uphold the finding in whole women's health, the chief decided that he would follow stare decisis. Now we're going to be confronted with the next case. That this is the Mississippi case. So it bans most abortions after 15 weeks. And so this is a significant change. There are a number of states that are doing the same types of things and establishing the same policies. And these are the comparative arguments that those arguing that the Mississippi abortion law should be overthrown should simply follow the precedents of Roe, Casey, Whole Women's Health, and Russo, all of which established these lines and these tests, and that abandoning this viability line would mean that some states were able to basically completely prohibit abortions, and that there would be really no access to abortions if in these states where these types of procedures implemented. So basically, the state of Mississippi is asking U.S. Supreme Court to overturn Wade, and that the fundamental argument that the states should be the decision point on abortion policy. And that actually means that the U.S. Constitution should not come into play. So that's quite a departure. I got a copy yesterday of the American Bar Association's amicus in the Dobbs case, and find it very interesting, and it's good reading if anybody wants to get it. It's on aba.org. They have you can find the amicus brief of the American Bar Association. Basically, it's interesting. It seems to me they are writing a lot of this brief to Chief Justice Roberts, because there are a number of votes that you can probably count on to say that they would follow Roe, Casey, Whole Women's Health, and Russo, because they believe that that's the proper result and there should be a liberty interest surrounding the rights to abortion, and Roe should not be overturned. Roberts, who may be less inclined to follow that substantive line of thinking, did find the logic of upholding precedent important. So in this brief, they argue that it's important to recognize the longevity of these decisions, that in fact, these constitutional rights have become part of the constitutional fabric, accepted as a liberty interest in the country, and that a number of individuals in the country act in reliance on the existence of the right and have been acting on it, and that finally there is no basically flawed reasoning. These are the basic reasons to follow stare decisis. So this is an argument saying there is no rational reason to overturn this chain of cases, and that the Dobbs case presents essentially the same question, and that therefore, if you're going to rule in favor of Mississippi, you're going to have to change the precedent, upend these liberty interests, and overturn the reliance of individuals who have relied on the existence of these policies. So, well, fundamentally, that video just described the current situation and debate, and the fact that there are some legislative solutions being sought, et cetera. But in any case, to talk about the actual Texas law, which I think many of you have heard about now. So it bans abortion when cardiac activity of an embryo can be detected, which is approximately 6 weeks. And according to medical experts, this is a pragmatic concern because many women won't be aware, and a staff analysis there indicated that 8 out of 10 women would be denied access to any abortion care based on this determination. And the most interesting thing about this is this policy is not enforced by government. It's instead enforced by a private cause of action. So provides a quote $10,000 bounty to persons bringing a lawsuit, and the target is anyone who aids or abets the abortion, not merely medical providers. So the object of doing this was to try to avoid the fact that this would be state action, and clearly the previous precedents and constitutional restrictions on state action are targeted on state action. So this effort is to say, well, there is no state action. These are private individuals. The policy also has no exceptions for rape, incest, psychological condition, or disability. And other states are considering the same issue. The Department of Justice has pending litigation. So their argument is state laws are generally invalid if they violate the right protected by the U.S. Constitution. But the question is the private cause of action the barrier? That is the only state actor involved, the court. Now, there are cases that say that if you turn over police powers to private individual, they become agents of the state, or that the state action becomes so entwined by individual private action that it still is reviewable. And so that is an argument to expect, that just because you have deputized someone, they are still enforcing and acting as a state actor and might be considered an agent of the state. And if that argument were successful, then you would be back on judging on the same line of cases and not avoiding the standing issue. And at this point, the Supreme Court has denied emergency preliminary injunction. There is no decision on the merits, and there were some implications that a merits review might be different, but at this point, we really don't know. So Ellen, I am glad to take questions, and I'm glad to take answers if anybody has them.
Well, John, let me start then. The pitch is to Roberts, obviously, not only from the ABA, but from other amicus briefs that have been filed and from the parties themselves. Where do you think this is going with the Supreme Court generally? And what issues do you see arising in the coming term with respect to the abortion and the reproductive rights issues?
Well, the Mississippi case is first, and it doesn't have, you don't have to debate the vigilante issue.
Right.
So it is highly similar to the previous cases. So therefore, you might expect Roberts to be willing to follow it. The question is someone else? And I don't think we know, because this is the Mississippi case. If decided in that direction, would essentially overturn Roe.
Right.
So yes, the Texas case is important, but Mississippi comes first.
Shirley, you have your hand up. You have a question?
Well, yes, this all seems extremely punitive toward women, even to have reached this vigilante state. I wonder, do you have any sense of how men generally feel about the women getting an abortion? Is it all based in biblical sense, or how do men take a stand on abortion rights? Any idea?
I can only speak for myself and other men that I know. That if you view this as a liberty interest and that actually invades a highly personal decision for women, that men, as you saw, you couldn't hear the White House press secretary. She was asked what the president's view on abortion rights was, and she said he believes that women should have the right to make decisions about their own body. And then she asked the questioner, well, I guess you haven't had the experience of being pregnant.
I guess not. But it is so highly divorced from the reality of supporting babies. It's, as I've said before, it's like accusing women of being engaged in a solo sport, and they've got to be punished for it.
Okay, I have a question here in our Oak Room. One moment, and then we'll go back to our Zoom questions.
My question is, all of this is between men and women in the court. What about the children, where the dads drink alcohol and the mother is on drug and the children can't even sleep anywhere or get any food? What about the children that I produced? I feel so sorry for them.
That's of course a tragedy as well. And a separate question of our obligation to take care of children, and a good question.
Anne Marie, if you'll unmute.
Thank you. I have a question about how science has been used in establishing previous case law on this. And that is that after Roe versus Wade, there have been many cases, particularly on the state level, that have used science to establish questions of viability and so forth. And I don't really pretend to know the details of all of that. But what interests me is the whole question of 6 weeks, and of course what everybody has talked about regarding whether or not an electrical impulse can be an establishment of starting of life. the science on this is pretty clear, and that is that that's not a heartbeat. That's an electrical impulse. It doesn't mean that the heart has been established. So I wonder, I haven't read anything legal that even addresses this point as to whether or not that is going to become an issue in this particular court case. I wonder if you had found out anything on those lines.
Well, it will be an issue. It's certainly an issue in the debate. The justification for the 6 weeks period does seem to, the title of the bill is heartbeat though. So there is some attempt, if the state is trying to demonstrate a compelling state interest, a way to do that is to say we have a compelling state interest in a viable life. So they have to, that would be an assertion. And if you're going to have a trial, you could have evidence, as you're describing, to say that is not the case, and what you're asserting as your compelling reason is not accurate. So then the questions end up being, do you have a justification that overcomes the burden? Clearly, this is a burden and intended to be, and we understand that. So the question is, what are the justifications? And in the previous cases, you've seen that the court has said that those justifications are not adequate. So unless you totally ignore Roe versus Wade and say there is no liberty interest involved, which I would find it hard to believe that they would just ignore it completely, that they have engaged in a balancing test in which, at least with Roe versus Wade, the scales were tipped in favor of the abortion rights, and that those scales seems to have changed over time to be less tilted in that direction. So I have to imagine that debate, that factual debate, is part of the justification.
Okay, John Reiskin?
Yeah, if the court rules to allow the Texas law, then it's up to each state. Basically, it's thrown back to the states, and many states would ban abortion, and others wouldn't. So people have two questions. One is, can federal law just be passed to allow abortions? On one hand, and then realizing that in 2 days or maybe tomorrow, our state constitution raises the minimum wage, which was not favored by the powers that basically rule the state of Florida. Could a constitutional amendment to the state constitution guarantee that right within this state? So it's a question, those are two questions of how to basically allow women's choice. Of course, neither one would guarantee it nationwide, of course.
You correctly identified the fact that that if you allow the Texas case to proceed, you have said that this is a state-by-state decision. Florida, yeah, the answer is yes, you could do a constitutional amendment. There's also, Florida is interesting because there's a constitutional right to privacy in Florida, Article 1, Section 23. And
thanks to you.
well, yeah, thank you. Well, Yeah, introduced that in 1978, and it most definitely has had an effect on abortion rights. So it creates an individual right to be free from government intrusion. So many of these ideas that could prevail in other states without that individual right should fall in Florida. But could you do a specific amendment? Yeah, I think you could.
David, go ahead.
Hello, John, and thank you for tackling this controversial issue. I'm not really clear about why the Supreme Court kind of really ignored the importance, the immediate importance of this. This is a highly controversial issue. And upon its becoming enacted, it immediately put at risk the health, and not only the physical health, but the mental health of a large number of women in the state of Texas. Why did the court not use some of its power to delay action on this?
Hi, David. Good to see you.
Good to see you too.
It's hard to say why, because clearly your statement is accurate, that it had an immediate effect on the rights of women in Texas. Their justification is that it procedurally didn't bring the full question before the court, that it was asking for an injunction, and therefore there's a different standard of proof. But of course, all you have to do is read the dissents to understand that that if you believe in the existing precedents, then you should issue a preliminary injunction, because the likelihood of that statute surviving under existing precedents should be low. So that's it's hard to understand that, and the majority just simply, did not want to decide. We can hold out some hope that when confronted with the realities and other various aspects of the controversy, that can flip, and I think it still can. But interestingly, we get Mississippi first. I mean, that's going to happen. And if Mississippi is decided poorly, if Mississippi is decided to allow the upholding of the Mississippi law, then we can't anticipate much from Texas. Although I still think the vigilante aspect of the Texas law might result in saying, well, you can pass a law like Mississippi, but you can't pass a law like Texas. So I cannot tell you why.
Thank you for trying.
Yeah.
Anne Marie?
Marie, did you have another question?
I did, and I'm afraid that I got cut out of the Zoom. I had to reconnect with Zoom, so I didn't hear the answer to my last question. But given that I see a couple of weak points here that the Solicitor General or whomever may argue on this to the Supreme Court, one of them I think is scientific viability question, that whole issue there. But whether or not the law would stand or fall on that basis, I don't know. I don't know what the court might do. But the two weak points that I really think are critical in this bill is the empowering of citizens to enforce it, the vigilante aspect, And of course, there's all kinds of case law preventing federal agents, posse comitatus, from interfering in local and state criminal enforcement. I mean, there's all kinds of case law on that. But citizens and the vigilante aspect I would find very troublesome. And the other one is the whole question of bounty as a possibly motivating factor as to why someone would want to participate in this and pursue it all the way to its legal end in court. And I'm wondering what you think might be an attack or a possible attack out there regarding taking down this particular bill?
The well, first, it's not a criminal act, and so the state, a private individual, isn't enforcing criminal law, but they are enforcing the law. So there are cases. There's a case, Brentwood Academy. It's a 2001 case. For those of you who just love to look up Supreme Court cases, it's 531 U.S. 288. It deals with a private agency that enforced disciplinary measures against public schools. And the court ultimately held, well, that this was the agency, even though private, was so closely entwined with public action that their activity would be considered state action. And once their activity is considered state action, then you can subject it to constitutional tests of the 14th Amendment. So in reading the 14th Amendment, it is to prohibit states from discriminating, violating equal protection, et cetera. And the 14th has been used to extend other constitutional rights, such as this. So if they're trying to totally privatize enforcement, that's the effort. The effort is to try to keep it from being state action, because those constitutional limits are on state action. They're on state action and state statutes that have restricted abortion activities, placed undue burdens, imposed restrictions on individuals and clinics. Now, you can logically say, well, this state statute does that. And that's one of the arguments of the Justice Department, that it's still a state statute. And isn't that state action? And if I am a bounty hunter, or if I'm someone, I must go to court to enforce that. Now, the court, isn't the court part of the state? But so there are two different arguments. One is the court part of the state, which they might be less inclined to do, but have they created agents of the state by essentially giving individuals the power to enforce a state law? That's not an unreasonable argument.
Back to you, David.
Do you know if the Texas law prohibits medical abortions, that is, with a prescription pill that the patient gets from the pharmacy?
You mean the abortion pills?
Yes.
In reading that act, I don't remember there's specific reference to pills, but the timeline is the principal barrier. Does anyone know differently than that?
I just remember, John, the timeline was extremely abbreviated.
Well, it's it's the 6 weeks.
Yeah,
So presumably, I suppose if you took what, a morning after pill or something soon, that would not apply. I mean, that the statute would not apply because it hasn't been 6 weeks.
right.
And the interesting thing is, in the implementation of this statute, when someone has identified someone, and it's not the person who gets the abortion, it's the person who facilitates. So if it's the driver, counselor, whomever, as an element of proof, you're still going to have to show that it's after 8 weeks or 6 weeks, which is interesting. I mean, you're going to seek your recovery, and part of seeking your recovery is going to have to be that the abortion that was facilitated occurred after 6 weeks. It's very strange, but
Of course, the burden is still on the woman to take immediate action.
yes.
And I'm curious about something. When you have I don't know if I assume you've discussed these cases, Missouri and Dobbs and the Texas case with your students. Do they see a differentiation here in terms of how the court might split the baby? No pun intended.
No, actually, we haven't gotten to abortion cases yet in the class, so I can't say how they'll react.
Okay,
And
fair enough.
how does and how you see the court? I suppose you would look at the most recent cases. So before Texas, it was 5-4 with the chief voting to uphold because of stare decisis.
Right.
And in this case, even the Texas case, with the chief on the side of saying we should enjoin the activity. So it is difficult to predict which of those 5 justices will vote differently. And they'll be confronted with the issue very squarely in Mississippi.
Ellen, I'm back here in the Oak Room. I have a question from the audience.
I am wondering if there are any early indications from the newer Supreme Court members of how they would come to this question.
The only indications you can get would be from their votes on the Texas case.
Nothing before that.
Not on this issue, but they have voted to take the case, the Mississippi case.
Everybody voted yes on that? Or isn't that the way it works?
Not everybody has to vote yes. I don't know what the vote was,
Okay.
but that's, you could view the fact that they took the case in a couple of ways. Did they take the case so that they would have an opportunity to overrule Roe versus Wade, or take the case as an opportunity to clarify the last several cases and then prevent what is likely to be a multiplicity of state approaches? I mean, there already are, in the Mississippi case, there are a number of other states that have quite similar restrictions.
Okay, I have another question here, and then we'll go to Alice Gridley on Zoom.
This isn't a question, it's just something that's puzzled me through all this and through the last few years. The women who are saying they want control of their bodies, but yet they have become pregnant. Now, I'm not talking rape and incest and something like that, but they've had plenty of opportunity to prevent pregnancy. And now that they didn't practice control of their bodies, they're trying to get rid of the fetus.
Nodding head. Okay, Alice, go ahead.
Thank you, John, for this session. This may be an oversimplification, but these rulings are political rulings catering to evangelicals. And isn't there a constitutional rule that there's a separation of church and state? Does that have any relationship at all to these cases?
There is, Alice, a separation of church and state. Most certainly. None of the cases, none of the justices' decisions or opinions will reflect that as a reason. I mean, the reasons are that really begin grounded in states' rights, because these are all state actions. And that if the rationale that you'll see in those cases is that this should be a decision of the states, and that this is a constitution, this is an area of law that shouldn't be mandated or prohibited to the states. The states should be able to make their decisions, so that some states would be more restrictive than others. But I mean, of course, that's the same debate has occurred in over the last 100 years in racial discrimination. That's a states' rights issue. And that's what in Brown versus Board of Education, once you made it a constitutional right, a federal constitutional right, then the states no state could contravene. And that's the distinction. Is currently Roe versus Wade is a United States constitutional right, and under Brown versus Board of Education, equal protection does not mean separate but equal. And so therefore, separate but equal treatment by the states in schools was a violation of the United States Constitution. Therefore, no state could do it. And the argument before that was, yes, each state could make its own decisions. So it's no one will say in their decision that it's based on religion, because that would be, if you're basing a statute on religious, solely on compliance with religious doctrine, then that would be a problem.
Thank you.
Okay, Ellen, I don't have any other questions here or on Zoom. Any final comments?
My only final comment is, John, thank you so much for your time and for participating again, and for taking on a very, very difficult issue, which I think we're all going to be watching in the coming term, because obviously, as you said, Mississippi's first, and we go from there. So
Thank you for inviting me to participate. I see a raised hand. Pat?
It just went up. I was going to grab it. Go ahead, Pat.
Hey, John.
Hi.
I have it's kind of a concern. I wonder, this is so political. I mean, regardless of which side you're on, it's so political. I'm pretty sure a lot of male politicians who are screaming don't care. Some of them have even never cared before, but now they do, because it's the political, it gets them a vote. And we all know, humans being what they are, any kind of law you pass is not going to prevent unwanted pregnancies. And am I wrong in saying part of the reason that these laws were passed to begin with, Roe versus Wade, was because mothers, women, and their babies were dying because they were getting these illegal abortion, the coat hangers, the whatever, and there were so many deaths of both. And so that's sort of, to me, a conundrum, plus the fact that the politicians, they care about the baby until it pops out of the womb, and then they don't want to pass anything to take care of it. A lot of these babies are born to poor families, and look how long it took our governor here to accept the federal aid for children. And so to me, personally, I'm not a fan of abortion, but I understand that, it's, if you want to go to religion, it's between God and the person as far as judgment. But do we, so are they considering the increase in deaths like we had before and things like that?
Well, during Roe versus Wade, that was certainly, those statistics were discussed, that that the fact that abortion was illegal didn't stop it. There's also an interesting situation that's occurring with Texas. There are, I guess, there are individuals seeking abortions who are from Texas who are traveling to other states. And so some people suggested, well, gee, why wouldn't a creative attorney general from New York sue Texas, saying that your law is compelling us to expend Medicaid funds on people who should be in your state? That's pretty creative, but in any case, yeah, Pat, there's the dangers were certainly discussed during the initial Roe versus Wade.
Yeah, well, that's my concern. This is a political, and it's not really about women's health or the baby. And in the long term of looking at it as a full picture rather than for or against. So thank you, John.
So Ellen, well, thank you all for your good questions and for coming. And Ellen, by the way, from time to time, I think I'll send you, I have groups that have interesting policy forums by Zoom, and I'll send those to you, and you can forward those to your troops if they want to attend.
Okay, that'd be great, John. I appreciate that. Everyone have a good afternoon. See you soon.
Thank you, everyone. We'll see you next week.
Thank you.
Thank you.